But then there are limits within which the judicial activism should act. As I always say, the judicial activism should not turn into judicial adversaryism or judicial terrorism. Ultimately, our constitution believes in the separation of powers between the legislature, the executive, and the judiciary.
So many critics see this as a overreach, and sometimes even bypassing the executive.
So therefore, at times, as I said, like we did in the demolition judgment or the bulldozer justice, where we found that the executive was acting in excess. Executive was acting as a judge in their own cause, merely because a citizen was found to be involved in a criminal act. His houses were demolished. And we found that this would amount to not only violating his rights, but the rights of inmates of the house, his brothers, sisters, mother, father, children. And that was like taking a law into hand. And we also held that the right to shelter is a fundamental right, and therefore laid down guidelines. So that is a case wherein I would, it's not proper for me to justify my judgment, but I think that would be a case where a judicial activism should be promoted, but not beyond a particular limit.
Sir, bulldozers are still bulldozing at many places.
Yes, so therefore we had given liberty to the citizens to knock the doors of the high courts wherever there was a violation. And we had also expected that wherever such a grievance is brought to the notice of the court, we had laid down stringent measures that the person who is indulging in violation of the orders of the court would be guilty for the contempt of court. And not only that, we also directed that such demolished house, after following the proper procedure, is found to be illegally demolished, then the government will have to reconstruct it and recover the amount from the persons who are guilty.
Sir, did you face any pressure from the executive ever or politics politicians?
No. Genuinely no. I answered that question on Saturday when I was meeting the journalists also.